Can or should I have more than one trust? Nancy Marie Dowling, the principal attorney at Solutions Law Group, explains, a person certainly can have more than one trust. The question of whether they should depends on individual circumstances. Almost everyone can benefit from having a revocable living trust. There are multiple potential benefits. The most commonly known benefit is probate avoidance. Most people think of what I call death probate in this context. This is where a person dies with no estate plan whatsoever or with a will-based plan. In either case, if assets are in the person's name, the assistance of the probate court is required to make sure that the assets are secured, inventoried, and accounted for, that the person's outstanding debts are paid, and that their remaining assets are distributed to either their heirs at law, persons who inherit without a will according to a one-size-fits-all plan created by the state legislature, or devisees legatees, those named in the person's will to inherit. What people often don't realize, however, is that there is another type of probate that can be avoided as well. I call this living probate. If a person becomes unable to handle their affairs, a guardian and also a conservator, if there are assets, may need to be appointed. To accomplish this, probate court proceedings are required to have these fiduciaries appointed to act under court supervision to handle the person's personal and financial affairs. This may end up being someone you would not have chosen. In addition to the delays that can arise in procuring such appointments, leaving the person to be protected vulnerable, there are also ongoing expenses involved that can be avoided. Some that come to mind include filing fees, annual accounting fees, guardian ad litem fees, compensation for the fiduciaries, and not to be forgotten, attorney's fees. Such fees can extend for decades while the incapacitated person remains alive. All diminish the person's estate. As you may now understand, living probate is worth avoiding, and a living trust where the person designates a trusted trustee to act for them is one of the most secure ways to avoid it. A trust can be particularly helpful in many circumstances. For example, when minor children are left without their parents, a properly prepared trust avoids the delay of waiting for court appointments of fiduciaries to obtain the required authority to act on their behalf. Otherwise, children may be left in a precarious situation without available resources and protection. Also, for some high net worth people, it may be advisable to irrevocably transfer assets during life in order for them not to be included in their taxable estate at death. A trust is the best way to protect those assets and ensure they go to whom they are intended for. Certain types of charitable trusts may be used for this purpose. Another reason one might have more than one trust is to save assets from Medicaid. Each state has its own name for Medicaid, as Medicaid is the federal term for the joint venture between the federal government and each state. In Massachusetts, Medicaid is called Mass Health. Call now to uncover your personal solutions or visit our website at www.solutionslawgroup.com.